Welcome back. I'm Chris Prescott. I'm a partner at Patel Law Group. This is the third installment of the H-1B video series. In the first video, I gave an introduction to H-1Bs. In the second video, I talked about benching and the 60-day grace period. One of the things I mentioned in the last video was the need to possibly file a H-1B amendment where there is a change to the original terms and conditions of employment. Today's video is going to focus purely on H-1B amendments because this is an issue that crops up frequently, and it's important for employers and employees to be aware of the need to file an amendment. It's particularly important because of COVID-19. We have a lot of employees changing work locations, perhaps taking a reduction in pay or a reduction in hours. So it's extremely important to make sure that the H-1B amendment is filed so that the employee can continue to maintain their H-1B status. So an amendment petition is where you have an approved H-1B and then there is a change to the terms and conditions of employment which requires the employer to notify USCIS of the change. It's worth noting that not every change requires an amendment to be filed. It's only if it's considered to be a material change, which essentially means a significant change. So it could be a change in job duties, for example. Minor changes, such as a small increase in pay, would not be considered to be a material change. As I said, it's important to file the amendment to make sure that the H-1B employee continues to maintain their status. What needs to happen is that the amendment needs to be filed first and then the change occurs. The reason for that is because if the change occurs first and then the amendment is filed, there's always a possibility that USCIS could either deny the application or approve the application for consular processing. Now, consular processing has become a lot more difficult during COVID-19 because we have consulates that are closed, we have travel restrictions in place, and then we also have the presidential proclamations, which have provided a lot of uncertainty. So the key is to get the amendment filed and then implement the change. So we're going to look at some of the circumstances which require a H-1B amendment to be filed. So a reduction in hours would be considered to be a material change in employment. So for example, if we have an employee that's working 40 hours a week and the employer wants to reduce the hours to 30 hours a week, it would be necessary to file a H-1B amendment. Part-time employment is okay for H-1B purposes, but it is crucial that the amendment is filed prior to the reduction of hours. And the reason I say that is it's going to be fairly obvious to a USCIS officer if the hours have been cut for, say, a period of 6 months and then the petition is filed. And the reason for that is because that we have to submit copies of the employee's pay stubs to show that the employee has maintained their status. So again, if they see that the hours have been cut first, they're either going to deny the application or approve it for consular processing. So a reduction in pay is another material change in employment. This is a bit of a tricky one, and I typically wouldn't recommend to a client to reduce the pay unless there is a legitimate business reason for doing so. Because of COVID, there may be such a reason. If an employer has lost, clients, contracts, revenue, there may be a legitimate need to reduce the pay. What I would tell you is that USCIS doesn't typically like it because when you file a H-1B petition and you submit an LCA, you're agreeing to pay a certain wage for a 3-year period. So then when you try and reduce that wage, you may find that USCIS do challenge you on that and issue an RFE. So I'd like to give 2 examples of how this could work. So in the first example, let's say we have an I-129 H-1B petition which is filed and the prevailing wage is $77,000, but the offered wage, in other words the wage which is listed on the petition, is $85,000. Well, if the employer then tries to reduce the wage to $80,000, even though it's above the prevailing wage, because it's a deviation from the original terms and conditions of employment, in other words, the offered wage that's listed on the application, I would still expect an amendment to be filed. USCIS is still likely to ask you what the legitimate business need is to reduce that wage. However, in the second example, let's say we have a petition that's filed with a prevailing wage of $77,000 and the offered wage is also $77,000, and then let's say 3 or 4 months later this individual gets a pay rise to $85,000, but then COVID hits and the employer decides they have to then take back that pay rise. Well, if they take back the pay rise, or let's say they reduce it to $80,000, because that wage is still above what's listed as the offered wage on the petition, I think in those circumstances it's less likely that an amendment would need to be filed. I would certainly feel more comfortable advising the client, because essentially you've got a pay rise, you've reduced it back, but you're still paying more than both the prevailing wage and also the offered wage. Each case is going to be dependent on the facts, so it may depend on how significant the pay rise or the decrease is. If in doubt, speak to an immigration attorney to determine whether an amendment should be filed or not. A change in job duties is the next issue that we'll look at. If there is a significant change in job duties, that would be considered a material change in employment. If it's just a change in the job title, for example, with no significant changes in the job duties, that would not require an amendment. In terms of promotions and pay rises, they don't necessarily require an amendment to be filed, but then it does depend on the promotion and the pay rise. So for example, if somebody gets a $2,000 or $3,000 pay rise, that's typically not going to require an amendment to be filed. However, if somebody gets, say for example, a $30,000 pay rise, then that would be a strong indicator that they've taken on additional responsibilities. And in that situation, I would typically advise clients to file a H-1B amendment. Again, the facts of the case is going to determine whether an amendment needs to be filed. There's no hard and fast rules, so if you're unsure, speak to an immigration attorney. A change in worksite location to another worksite which is outside of the metropolitan statistical area, aka the MSA, does require an amendment to be filed. This is probably the number one reason that employers file amendments. It's certainly a big part of our practice, and we see it a lot with IT staffing, IT consulting firms, where we have an employee working at one location and then suddenly that project comes to an end and it becomes necessary to transfer the employee to another location. So for example, if you have an employee who is working in Dallas, Texas, and you wish to transfer that employee to New York City, you would need to make sure that you file the amendment prior to the employee changing locations. I've certainly seen RFEs where the officer has claimed that there is evidence within the petition that the employee changed locations prior to the amendment being submitted, and that becomes problematic. So again, very crucial to make sure that you follow the sequence of events, you file the amendment, and then the location takes place. Sometimes these projects do come to an end suddenly and it's not possible to do that, but I would say as a best practice to try and do that wherever possible. So we talked about a change in worksite locations where the new worksite is outside of the metropolitan statistical area. However, if the new worksite location is within the same MSA, then an amendment is not strictly required. So, for example, if you have an employee working in Dallas, Texas, that then moves to another client location also in Dallas, Texas, an amendment wouldn't need to be filed. However, the original LCA would still need to be posted at the new client location. One of the things that we've seen a lot of during COVID-19 is employers allowing their employees to work remotely. The question is then raised, is a H-1B amendment required in those circumstances? The answer really lies in where the employee lives and whether that's considered to be in a normal commuting distance of the worksite location. So I think anything beyond an hour is unlikely to be considered a normal commuting distance. But if you have an employee that lives, say, 20 minutes away from the worksite location, then that would be considered normal, in which case you don't need to worry about filing an amendment. One thing to note is that when the employee works remotely, the original LCA is supposed to be posted at the home location. It sounds kind of silly because you're having an employee post a notice which only the employee and his family is likely to see. However, it's still technically required, so I would ask the employee to go ahead and do that. One of the things I wanted to mention is that even though the guidance from USCIS doesn't necessarily require an amendment to be filed where it's within the same MSA, the consulates, or certain consulates, have taken a different view. So we've had clients where an amendment hasn't been filed, but then when they've gone to the consulate has insisted on an amendment. So what I would say is, even though an amendment is not required, if you have an employee who is traveling at some point soon, you may want to consider filing an amendment because it's going to make their visa stamping interview that much easier. Short-term placements typically do not require a H-1B amendment to be filed, so this is where an employer places one of their workers at a location for a temporary period of time. It's permitted for up to 30 days, and in certain circumstances it's allowed for up to 60 days. For the 60-day exemption to apply, the employee would either need to maintain a permanent workstation at the permanent location, or they would need to have a permanent residence close to the worksite location. So in the majority of cases it's 30 days, but there are certain circumstances where that can be extended to 60 days. An amended H-1B petition is generally not required when an employee is going to a non-worksite location. So this would include an employee that is going to a location to attend a training seminar. It also includes an employee who is traveling to a location on a temporary short-term casual basis. So this can be reoccurring, it just can't be excessive. So in the first video, I discussed the filing fees which have to be paid for a H-1B petition. So there's typically three fees. You've got a filing fee, which is $460. You have a fraud fee, which is $500, and then you have a training fee, which is either $750 or $1,500. That's going to be dependent on the number of employees you have. So when you file a H-1B amendment, it is necessary to submit a brand new petition, which means paying new fees. However, what fees you have to pay depends on whether you're filing for a pure amendment or whether you're filing for an amendment and an extension. So the fraud fee of $500 does not need to be paid for an amendment petition. If you're filing a pure amendment, in other words, you're not asking for an extension, so if you have an approved H-1B and there's 2.5 years left, you may just want to file a pure amendment, and that means you're just asking for the same validity dates as the original petition. If that's the case, you would just pay the filing fee, which is $460. One thing to note is that USCIS has recently increased their fees, so effective October 2nd, the filing fee will actually be $555. If you want to file an amendment and an extension, so let's say you have an approved H-1B, 2.5 years in, you feel like you have to file an amendment, in that case you're more than likely want to file an amendment and an extension. You would then have to pay the filing fee, and you would also have to pay the training fee. So it's very important to make sure that the filing fees are paid correctly, because if you have an employee that changes worksite locations and you file an amendment with the incorrect fees, there's always a possibility that USCIS may return that application. If that happens, then you're really putting your employee's status in jeopardy. To conclude today's video, it's important for both employers and employees to be aware of the need to file an amendment. It's especially important for employers to be aware so that they can continue to comply with the regulations, and it's also important for employees to be aware of when an amendment needs to be filed because it could impact their status and their ability to remain in the US. If in doubt when to file an amendment, please speak to an experienced immigration attorney. Please also like and subscribe to this video. You can also follow us on LinkedIn at Patel Law Group, and thanks for watching today. Thank you.